Very good afternoon. Welcome to this licensing Subcommittee D meeting. I'm now going to switch over and briefly go through, for all those watching and also the meeting participants, the remote meeting protocol. I will finish and then I will hand over to, and then we'll go over to the first agenda item. So this is the protocol for the remote meetings. Only speak when you're invited to by the chair. If you wish to speak, please raise your hand and direct all communications via the chair. Will everyone please ensure that their mics are muted when they are not speaking, apart from the chair, who does not need to mute their mic at any stage. Okay. When speaking, be succinct and do not exceed the allotted time frame. Highlighted to a specific page or pictured report refer. If you're having technical difficulties, please use the chat function in the Google Meet to alert the meeting or dial into the phone number using the PIN provided within the alert. So we've already done that. Please do not use the chat function for putting formal questions to the subcommittee. Any persistent disruptive behavior will result in a removal from the meeting. If there is more than one application, parties are advised that after each application is heard in turn, as set out in the agenda pack, the subcommittee will not retire each application. The parties can contact the licensing service to be informed of the decision the following day, or can simply wait until they are notified of the decision. Applicants and all other parties will be asked to leave the proceedings after the item is concluded. Once all applications have been considered, any remaining parties will be asked to log out of the hearing. Please do so promptly so that councillors will have the opportunity to deliberate and make a decision on each application they have heard. Each party will be notified of the decision within 5 working days. That concludes the protocol for remote hearings, and we will now go to the formal agenda and agenda item 1, which is the election of a chair for this licensing subcommittee meeting.
I'd like to nominate Councillor Pluvier.
Thank you. Okay, everybody. Thank you. We'll start the agenda as set out. We don't have any apologies for absence. Do we have any declarations of interest? None from myself.
None.
Lovely, thank you. Okay, we don't have any minutes of previous meetings. Just before we go on to, I think perhaps the best thing quickly to do now is for everybody to introduce themselves. So I am Councillor Pluvier from London Fields. I'll be chairing this meeting. My colleague is...
Councillor Brian Bell.
Thank you. Suba, would you like to introduce yourself, please?
I'm Subhashri Ramana, Principal Licensing Officer.
Thank you. Gareth?
I'm the Governance Services Officer for this meeting. I'm also be minuting this meeting as well.
Thank you. Channing?
I'm Channing Riviere, Principal Licensing Officer.
Thank you. Applicant?
And applicant, yes.
Applicant is Mr. Dadds.
I'm not the applicant for the review, so that's why I was just pausing. Sorry.
You are speaking on behalf of, as the applicant, I think, is the applicant here?
The applicant is the not
the applicant. So I beg your pardon. I beg your pardon.
I'm getting confused. Sorry.
Yeah, no, sorry. This is a review. You're quite right. I beg your pardon. So you are the premises. Speaking on behalf of the premises.
Yeah. So I'm David Dadds, chair on behalf of council on behalf of the premise license holder, who is on another screen here listening to the review hearing.
Okay, and just for clarification, that their name is.
It's Handel.
Okay, and are we able to ask them questions directly through you, or how does that work? You're going to speak on their behalf?
Yes, and if you ask a question, I will ask the question and take my instructions and then come back and answer it for you.
Okay, thank you.
Thank you.
Kerry.
Hello, Kerry. PC Kerry Ryan, Hackney Police Licensing.
Thank you. And the other police representative is?
It's PC David Atkins, also from Hackney Police Licensing.
Thank you. And Amanda?
Amanda North from Legal Services.
And Ola?
Ola Shibikon from Environmental Protection Team.
Thank you very much. Okay, right. So we'll the review proceedings. We're hearing the review of the premises license, Unit 7, Wasman Road. The review procedure is on page 1 of the agenda. I hope everybody has that. First of all, the licensing officer will outline the report, then the applicant for the review, which in this case is Hackney Licensing, will present their case. We'll hear other responsible authorities, and then we will be considering from the other persons who are represented, but they're not here to make their case, they're unable to attend. And then we'll hear from the premises license representative before we go into a discussion, and points to be made only by raising your hand through the chair, please. And then final remarks. And the consideration will happen after the meeting because we're online. So thank you very much. Without further ado, I'll ask the licensing officer, Suba, please to outline the report for the review.
Thank you, Chair. Licensing Service received an application for the review of the premises license from the Licensing Authority under Section 51 of the Licensing Act 2003 for Unit 7, 224 Osman Road on the grounds of prevention of crime and disorder and prevention of public nuisance, as stated in the agenda. Environmental protection, police and other persons' representation remains. We have received supporting documents from the applicant, other persons and witness statement from the police, which have been circulated. I have nothing else to add. Thank you, Chair.
Thank you. Any clarification? No. Okay. In that case, we'll go over to the applicant for the review, which I believe is the licensing enforcement.
Thank you, Chair. The review has been submitted on the basis of non-compliance that has been evidenced and a number of complaints we've received from the premises and the way it's been operating from local residents. So if we go to the beginning of the application and we've got the grounds for the review, it's actually in line with the Home Office guidance on the Licensing Act, Section 182, Chapter 1110, because we have engaged with the premises for a significant amount of time regarding these type of issues. So what you'll see from the review application is a timeline, and essentially a timeline of events outlining when we've received some of the complaints, and also outlining a initial failed test purchase and non-compliance with condition 31 of the premises license, which is a ancillary to food condition. We then invited the licensee to a formal recorded interview. You can see from the actual transcripts that's included and appended and also quoted in the application. We did clarify with the licensee what is required in order to sell alcohol without having food and not contravene condition number 31. Subsequent to that, we have gone on to receive further complaints, and then in July of this year, a test purchase was failed again in contravention of condition 31 on the premises license. So the combination of these factors has led the licensing authority to conclude that in reviewing the application for the premises license, we'll be seeking to have the outcome where the license is removed due to our lack of confidence in the licensee being able to comply with the conditions at all. So I have nothing further to add at this moment, Chair.
Thank you. Any clarification required at the moment? Thanks. Thanks very much. Okay, so I'd like to ask the other responsible authorities here who wish to speak in support of the review. Perhaps we could hear first from the police.
Madam, could I, Chair, sorry, do I get an opportunity to ask the applicant any questions?
You have the opportunity when you've in your address, you can address the points that have been made, and then you can ask questions in the discussion.
Thank you.
Okay. Okay, so now we would hear from the police, please.
Thank you, Chair.
Lovely, thank you.
I will go through my representations that I made and just clarify some points. So in my representation, I referred to a large canvas that was hung over the door that was advertising the sale of alcohol to be taken away. And at this time, the sale of alcohol for consumption off the premises wasn't authorised. So we went and spoke to the premises licence holder about that and gave them some advice. But unfortunately, a week later, we were still receiving complaints from members of the public that they were selling alcohol to take away. The statement that was attached by PC Neil Hunwick, who referred to the people sitting outside in the rear of the premises on the 17th of July. And we'd also previously received a complaint from the public on the 12th of July about the rear terrace being open, and then further complaints on 19th of July. So it seems to be that they were operating outside when the premises licence said that there should be no drinking outside. The other incident that PC Neil Hunwick referred to in his statement was when police were called to the premises on Friday, the 11th of September, quite recently, by a member of staff who stated that there was a large group of travellers inside the venue and they were refusing to leave. Having now read the police report incident, the staff member stated that they were hosting an engagement party. The staff member states that there were approximately 50 to 70 travellers inside and they were refusing to leave and causing problems, so throwing food around and generally being boisterous. And that call was received at 10 to midnight. There was another call made to police at 1:40 in the morning, a few hours later, stating that some of them were still outside, sitting on their chairs and continuing to drink. And that is what raised concerns for us, because not only are the conditions being breached on the licence, the alcohol being ancillary to food and the waiter-waitress service, but also the condition 33 relating to a maximum of 40 patrons inside at any one time, and also a breach of the coronavirus regulations, which govern that gatherings should not be greater than 30 people. And these breaches can incur quite a heavy penalty. And concerns police that staff and the management of the premises don't appear to have had control of the premises at that time. We visited the premises on several occasions. We've also requested CCTV in relation to the incident on September the 11th. We still haven't received that, and we haven't had any contact from the applicant or the premises licence holder in relation to that. So that's a bit disappointing that it doesn't appear that they're willing to work with us to combat these problems or to appear to work with us. So we do struggle to have faith in the operators. They don't at the moment to appear to be responsible operators, and that's our concern at the moment. That's all from police at the moment. Thank you.
Thank you. Any clarifications, Brian?
So the condition 8 on their licence ends with recording should be made available immediately upon the request of the police authorised officers. And you're telling us you still haven't had anything from the 12th of September incident?
No, we haven't.
Okay, thanks.
Okay, thank you, Kerry. And we'll now hear from environmental enforcement if we can. Ola, thank you.
Hello, everyone. I initially put in a representation, which I have withdrawn now because, number one, they've been able to carry out the works that we requested for them to do. And then number two, we've been having problems with the local residents to substantiate the noise nuisance. So we've not been able to witness statutory nuisance. With the music, we've agreed levels with them. So we haven't received any complaints since I set that level with them. So everything is fine from my part.
So can you just clarify for us that your complaint was to do with complaints about noise then, and you have worked with them, and that was music noise?
Music noise, yeah, about music, yeah.
Okay. And when you say the work, so what was required?
Well, there were some leakages. There were music was escaping to the flats above the premises, and also they had single glazed windows. So they've done acoustic windows, they've done lobby doors, acoustic lobby doors, and they've done the inside. They do the sound isolation of the inside of the premises.
Okay.
So there hasn't been any complaints since then.
So
Music.
Okay, and so you weren't able to record a statutory noise nuisance from the music.
No.
Can I just clarify whether all the complaints to environmental enforcement were regarding noise, or were there any other complaints?
Most of the complaints were received,
music noise, i.e. statutory nuisance. Were there any other complaints than music noise?
The use of the outside space, the smoking area, and I've been able to work with the lady, with the licensee, to reduce the number and also to move them further down away from the residents.
So you had complaints about people outside?
Yeah, in the smoking area, yeah. But since I spoke to the lady and requested that they should get the smokers down towards the gate. There's a black gate right towards the end of the building. So that's where they use now. We haven't received any complaints from any of the local residents.
Okay.
Yeah.
Thank you.
Yeah.
Madam, did he say he was withdrawing? I may have misheard.
Would you like to clarify? Are you withdrawing your objection? I'm sorry, are you withdrawing your review?
Yes, I sent email to one of my colleagues in the licensing team. Suba, would that be you?
Sorry, Ola, just to confirm, you have withdrawn your representation for the variation, yes. But for the review, we still didn't receive any confirmation, so that's why.
Oh, okay. Sorry, I thought the withdrawn that I sent to you was for the both for the variation of the premises license and also for the review. Okay.
No,
sorry,
yeah,
I didn't know that. Okay.
So Madam, through you, Chair, through you and the legal advisor, if the officer's confirmed that he's withdrawing on both, I understand.
Is that correct? My understanding from
yes, for me, I'm happy to. I'm happy. Okay.
Yeah, go on. So you're withdrawing from the review as well?
Yes. I'm happy with what they've done so far, yes. And as long as they keep to the level that we set, there shouldn't be any complaint from the local residents.
So you've been able to mitigate the noise nuisance that you had reported about music, and that's why you.
Well, they've been able to put. Yeah, they've been able to put noise mitigations in place, and ever since then, we haven't received any complaints.
Okay.
Yeah. Relating to music. Yeah.
Well, that's positive. Thank you. Any further clarification on environmental? No.
No, that's it.
No. I was just sorry. Thank you for your report. I'm just checking with Councillor Bell, but we're okay. So we understand. Are you happy with that? Also, Mr. Dad's good. Just nod yes or okay. Thanks. Lovely. Okay. Right. So as I say, the other
Chair, sorry, Chair, to interject. I believe the legal advisor has just put a hand up to clarify.
Pardon, Amanda. Yes, Amanda.
Sorry, Chair, to disturb you. But we've myself and Gareth have received an urgent email relating to the police's representations. I think it may be relating not necessarily to this application, but I didn't know whether or not you needed to clarify with the police if the email and the conditions they're referring to are for this application or for the next. I don't know if you if you want to check your emails. Because it wasn't possible to send it before the meeting started.
No, I
can clarify. It's for the variation.
It's for the variation. Okay, yeah. So that's fine. Okay, So we would have to, well, you can let us know when we deal with the application what the situation is with that then. Thank you. Okay. Okay, so we have the stand is the licensing authority and the police, who, and I just checked with the police that your evidence was that you wanted the license revoked, or that you have conditions in terms of this review.
In terms of the review, because we received both applications at the same time, we've spoken to Mr. Dadds about both at the same time. So we believe that what we have agreed for the variation will assist the applicant in the operation of the business, if that makes sense.
Yes, it sort of makes sense. It doesn't entirely make sense because they're different, and and we have a request from licensing that that we revoke the license. So it's procedurally quite difficult for us, but we will take that on board. And given that we will be discussing both applications together inevitably at the end, because we can't meet until the end of this, until both have been heard. I think we can handle that. Brian, are you happy with that? Okay, thank you. Okay, then I think we go over to the premises license representative to speak now, please.
Chair, could I ask, would we normally hear from the residents first? I don't know if there's any residents or interested parties.
Yeah, the residents that unfortunately are unable to attend. So we have written support for the review from 5 resident objectors, which the committee have read and will refer to in our decision making, and you can obviously refer to now, if that's okay.
Yes, thank you very much. Could you just clarify for me, how long do I have now to speak to you on these points?
Well, Mr. Dudds, you know that you have 5 minutes, but we're generous in this committee. We don't set up a time thing. If I feel that you are over labouring or going over things unnecessarily, I will indicate to you. But you know, how long are you asking for?
Well, I'll just start, and I'll try to keep within that time limit. But if I move over slightly, I will try to avoid repetition.
That's fine.
Thank you very much. I've tried to approach this review and the variation sort of from a pragmatic point of view. The review centres around predominantly, if I can sort of paraphrase, the operation regarding conditions and potentially the use outside. So as I understand it, from environmental health, they've withdrawn their representations on both and are satisfied that work has been done to address any issue regarding noise inside. And so that you're aware, the premise license holder has spent about £60,000 on works inside, and the landlord has spent about £40,000 on double glazing for the residence improvements outside. So it's actually just a little bit more than that. It's about £105,000 has been spent on doing works to make the premises secure so far as there's no noise breakout. And I think that is a positive. In relation to environmental health, they've also withdrawn in relation to us dealing with the smokers. So I will briefly touch on what I've agreed with the police, because I think that puts it into context in a moment. But in relation to the review is brought and must be brought on grounds of undermining the licensing objectives. So an alleged breach, even if it's proven, doesn't necessarily mean that there's an undermining of the licensing objectives, because obviously there's a separate process to, if it's in the public interest, to prosecute if there is a breach of the license. So because there's a breach doesn't mean that there's an undermining of licensing objectives or materially causes harm. So in relation to licensing, I've not seen any primary evidence, any witness statements, any evidence from, well, any witness statements or any evidence regarding any noise complaints from music to them. And I've not seen any written evidence or any evidence about from neighbours. So at the moment, I'm at a disadvantage to challenge the officer, other than to talk about the alleged breaches, which he has evidence. Other than that, I can't really address the residents. Normally the residents would come through environmental health, which you've heard. They've withdrawn. The residents appear to be satisfied so far as no further complaints. And also they haven't substantiated their complaints by way of a written form or a statement. Then in relation to the police service, oh, and by the way, madam, I did ask the environmental health or the enforcement officer to provide me the details of how many residents, are they from the same household, and provide me a bit more detail so I could have a look at that in more depth. I haven't received that, so I can't really speak.
So my understanding is that the complaints were made to licensing rather than to environmental.
Yes. So that's what I'm saying. I've asked licensing. Yeah.
And the complaints are not about music noise. I think they're about noise outside. But anyway, continue.
Yeah. Thank you. That's very kind. I have asked and sought clarification in relation to those matters from the residents, and they're not forthcoming. So I can't really expand on it anymore.
Sorry. I think are you saying you haven't received the papers which have the complaints from the residents and the emails from residents?
No, what I have in the agenda.
Sorry, there were supplementary papers circulated. So there was Councillor Adams' email, and then there were also the emails attached to the papers today.
What page? Well, actually, then I may be missing some papers.
I think it's a supplementary.
I've got the agenda, but I don't seem to have a supplementary agenda. When was that sent out?
Sorry, there were supplementary papers were circulated. I'm not quite sure when, which was Councillor Adams' email, a police witness statement and a support petition from you. And then there are objections on page 71, page 16. There's a whole bunch of objections.
Yes. So if I can just confirm what papers I have, I have got the statement from the police service. I believe I've got the agenda pages where they start from pages 68.
Yeah.
To the residents' representations.
That's correct.
24.
Yeah.
But as I say, those I've not got any. I've got no details of any name or address. I've got no details of dates and time.
Okay, I just want to ask the legal officer whether that in any way undermines the validity of the complaints.
Well, what I'll do is I'll make.
Sorry, Mr. Dad. Sorry, you raised a point, and I'm just asking my legal officer to just clarify that for me.
No, that doesn't invalidate the complaints, and normally Mr. Dads wouldn't be provided with the names and addresses of the complainants. He would just be provided with the details of the complaint, which has been circulated to all parties. And he would have been aware of what the supplemental papers were. So I'm surprised if he's saying he hasn't received them, but we can clarify that.
We have a number of resident complaints here, and it's perfectly normal for us to consider those in a hearing, especially if the residents themselves are not able to turn up. And that's correct. And they're very often they're redacted. So we understand from licensing that there are 5 residents represented there, and they're residents immediately local to the premises, Mr. Dadds, just so you have proper clarification of what we're counting as part of this review. Is that okay?
Well, I hadn't actually. I was making my representation. I haven't finished the point, so I understand you've sort of you've gone and asked a couple of questions, but I haven't made the point that I'm making about those representations. Okay. I know they're there in the agenda, but there's some points that I wish to make. But if I carry on with my representations, it might come clear.
Fine, absolutely fine.
Because obviously, I never suggested that the representations in the agenda are not valid. It's what weight you attach to those representations, given that the maker of the statement, the names and addresses are certainly not provided to me, so that we're prejudiced, so we can't respond to those. But in any event, I have asked where are they, in a sense of, are they within the site? And I will ask that through my questions when you will give me an opportunity to ask questions. And as I say, I've not got any witness statements from licensing of any further details other than the representations that we have in the pack. And the leading case on this is East Gwent. It's a High Court decision that says what weight you attach to a statement made by a maker who is not present is a matter for you, but whether, and it sets out that it's likely to have little or no weight as the maker of the statement is not present. But obviously that's the legal position. Oops. So that's the legal position, but certainly I'll carry on the point that I was making, is that from the licensing authority, I've had no further witness statement or any details of dates and times of any alleged complaints other than what I've got and you've read in the pack. Coming now to the issue regarding the point that I was making, is the undermining of the licensing objectives, is that with inside the premises, I don't believe that the police have not provided any evidence of any since the licensed premises was licensed in December 2017, anything of material consideration of crime disorder. We've not got, we've had a noise complaint, but we've addressed those by implementing and doing works and working with the environmental health. And in relation to outside, we are limiting, I'm proposing to limit the use of the outside to 9 o'clock and limiting the smokers thereafter. And you've seen that we've moved the smokers. I will just say what we've agreed with the police, though, so that you get an understanding of where we are, and I will talk about the conditions in a moment. But we've agreed, and the police would not object to the variation of the licence, that we would have a maximum of 95 customers on the premises, including the rear. I think this is on your email, that the rear outside area should not be used after 2100 hours. Except for 10 smokers who are not able to take drinks and glasses outside in open containers. That the hours for the premises are not going to be varied as we asked, but they will be 11 o'clock, 2300 hours Sunday through to Thursday, Friday and Saturday, midnight, closed by 30 minutes thereafter. And that the front of the venue, that there'd be no use for smokers. They use the rear area. The condition regarding condition 31, alcohol ancillary to food, is to be removed without any objection from the police in condition 25, and that there should be a dispersal policy. Now, the issue about outside, I'm going to just talk about 2 single points there, madam, to get to the nub of it. The inside, I'm going to talk about conditions, and outside, I'm going to talk about outside space use. But if I do that in that reverse order, so outside, what's happened is that principally two resident households have raised objections about us using the outside area and their loss of their space outside. And what has happened is, as a consequence of the landlord I would say, as the landlord, taking steps to say, look, this outside area that you've been using, the small garden area, is not your land. It's not your garden. It belongs to, in a moment, my client, the premises, and it's not to be used for a small residential garden for residents. It's not your land. And so the units along the side, they don't have any outside space. They don't have any garden area. And what they've been doing is using the side of the canal and our area as their garden. And because we are now using it as our outdoor space, they object to that. So in other words, I would say that those objections are vexatious, because obviously the outside space that they've been enjoying and using is not their land. So in relation to outdoors, we're using our space. We say we won't use it for any more than 9 o'clock. We will manage that outside area. And after 9 o'clock, we will limit it to no more than 10 smokers. You've heard from the Environment Health already that we are now managing that, and there is no complaint. The landlord has written to the tenants explaining, and the leaseholders explaining that it is our land and our use, and that and on that basis it's made it clear that this area that they were using is not their space, not their garden. Now, in relation to indoors, I just want to cover the point regarding the conditions. Where did we get to, and how did we get to a condition that alcohol should be ancillary to food? The original application that was submitted to the local authority made it very clear that the premises would be used. This is the description. Commercial premises to be converted to a drinking establishment for the following reasons: for the sale of alcohol, supply of alcohol, regulated entertainment, late night refreshment. And all the way through, it was always clear that this would be a drinking establishment. It would be food. You could have a drink. And on the day of the hearing, back in, I think, 18th of December 2017, the police offered up a number of conditions. My client, there were 12 conditions in total. My client agreed to those conditions and misunderstood the condition regarding alcohol ancillary to food. My client understood that to be, at the time, that as long as the food was available and for sale. Obviously, they didn't have legal advice. They didn't have advice at the time. But nevertheless, that condition was agreed with the police, and the police then withdrew their representation. But as you have heard today, I've spoken to the police, and the police are agreeable that that condition be removed as not being necessary or appropriate in relation to this premises and promoting the licensing objectives. So if the condition 31 and 25 are removed, and you can vary those here, madam, on the review application, you can impose all those things that I've just set out as steps to address the issues arising on the review. The licensing authority issue regarding the breaches of conditions would fall away because there would be no breach. You might say, well, that's a bit cheeky, Mr. Dads. But however, what I'm trying to suggest is that actually it was always set out that this premises would be a drinking establishment. That condition being put in or asked for and agreed to, being misunderstood as a lay client, misunderstanding the consequences of that, has in effect tied one hand behind this premises back, and they've spent a lot of money actually refurbishing, putting a building in place and employing people. And in essence, they probably didn't understand, they didn't understand the consequence that it would have to their business. They are not a restaurant. Obviously, they've had to be a restaurant operation to actually just comply. But that was never their intention. The intention was that they would be a premises that would offer food, provide food, but you could have a drink and without the taking of a meal. So what I have said to them, and what I've had open discussions with the police, is, look, don't go for additional hours. Keep the hours, or go for the slightly additional hours at Friday and Saturday. Keep within policy. Amend the condition to take off the conditions that you agreed to, which you didn't fully understand, because there's no evidence to support that condition. and it's not against policy. There's not a cumulative impact area. And since 2017, there's no crime of any note within the premises and the way it's been run. Okay, the licensing authority have concerns about breaches of conditions, but they would have to be treated by, if there is to be an establishment of innocence and guilt, there will have to be a separate laying of a summons if it's in the public interest. But today's exercise is about undermining the licensing objectives. Has the licensing objectives been undermined in relation to the operation? And there's no complaint at all about the operation inside of the premises regarding members of the public, other than noise, which has now been addressed. So inside, it being used as a bar, no one has complained to anyone about any crime, disorder, or any matters arising within the premises, and it's unlikely to be going forward either. In relation to music inside, that's, as you've heard, that's been addressed. Outside, I believe that the two main residents that have objected or raised concerns have been more or less out of because of loss of their amenity land. You will note from the plan, if I can just show you the plan, page 75 of the agenda. You'll see the canal side studios on the left. It's these studios that have, in essence, been using the canal side and the area at the front as their garden. And predominantly that's where we've had complaints to us about the use of the outside, because they've been using it as their garden. But you see directly opposite, you've got 2 to 11, 12 to 23, 24 to 38. We believe that area opposite is about 125 premises or people, flats in and around that area across the way, or certainly a significant number of people. And none of those people across the way have complained about our outside use. We've, as I say, we've had no complaints from the immediate neighbours upstairs now since we've done the works. And I don't believe we've had any complaints from people upstairs about the use inside. I mean, I'm trying to be pragmatic in the sense of, okay, how do we go forward? And as I say, because I haven't got the residents here and I've got no further details, I can't really do anything more than suggest that the main reason for the objections from the terraces on 1 to number, or 3A to number 1, has been predominantly around the loss of their amenity land outside, which was never theirs. So unless I can assist you further, I think that sort of summarises my position on behalf of the premise licence holder, and I can obviously answer any other questions. I will say, just very briefly, there was a concern raised about an operation late in the morning on the 26th of the 1st, 2020, and you'll note, I think there was a complaint that they were operating beyond their hours, but there was a temporary event granted on that day. I understand we've had 3 temporary events granted by the police service to 4 a.m, 4 a.m, and 2 a.m, and they were all granted, and no matters arising, as I understand it. So I'm sort of looking at what happens inside the premises, what happens outside the premises, and as I say, at the moment, I don't believe the licensing authority have issued any summons or any paperwork in relation to the alleged breaches. The statutory guidance is very clear that this is not the place to establish innocence or guilt. This should not be the place where a PACE interview is completely laid out to the public, including the name, address, date of birth, all in the public domain, which I think is a breach of GDPR. But in any event, there is no summons. It hasn't been prosecuted. It's subject to sub judice, and therefore it cannot and should not be discussed here today in relation to those matters. And we're not here also to establish innocence or guilt. The Licensing Act is very clear. We're here to see whether there's been any undermining of licensing objectives. We look at crime data, the complaints, and any undermining of licensing objectives as a consequence of the operations of the premises. And I say those issues that are complained of are escape of music, which has now been addressed, and people outside, which I say has been addressed, and the environmental health say has been addressed. But in any event, I say that they have been borne out by the loss of the alleged amenity space by the residents, which they don't own. So unless I can assist you further, that's the summary of our position as the premise license holder. Chair, you know the conditions that I referred to from the police service.
Mhm.
Have you got them in front of you rather than me read them out again? But obviously I'd like to refer to those and suggest to you on the review that you put those measures in place on the review to promote the licensing objectives.
I do have those in front of me, but I don't think that would be appropriate at the moment to say we would or wouldn't do that. We have to, because of the complex situation that we're, I will make a note of that, and we'll decide how we handle that when we get to deciding it. And
yes, that's very kind.
We have those.
Thank you very much. Thank you.
Okay. Just one thing in the thing, could you address the resident you mentioned something about access to the car park? It's on page 74.
I'm looking at page 74.
Yeah, so halfway down the page, I believe this will impinge, and then point 1, congregating by causing a loud noise, stop some customers spreading out into a car park on seating outside residents' houses. They appear to be given the access code to a gate to the car park.
Yes, well, the car park is our car park. The gate is our gate. But it's also the residents have a right to have access to the gate code so they can pass through on foot to their dwellings.
Okay, do we have you submitted a clear plan of all of this for the variation?
Yes, and what it is, Chair, the customers will come through the main entrance and not use the side gate anyway. I can say that. And the plan, so that it would be helpful to everyone, and I think it would be helpful just to refer to it, it's at page 105. I will just double check with my client about the gate. Could I just quickly do that, madam?
Yeah.
Thank you. Chair, just to confirm the drawing, the reason I wanted to ask the question, because there was an arrow coming through the gate at the bottom, and my client tells me that's for deliveries only, for the car park for deliveries, but any patrons, customers come through the front door, and that's how they're accessed the rear area, so they won't be using the gate. But nevertheless, that whole area is in effect we have access to. It's ours. It's not the residents, but the residents have a right to cross over it. Right. I don't understand this plan at all, but never mind. Is that? Are you looking at page 105?
And so
if I can just.
7 is the whole of the grey dotty area.
Yes, that's our inside of the premises, and you can see it says Unit 7.
Yeah.
The outside where it's got the canal and the outside area with the tables, that's our outside drinking area.
Again, just the dotty area in the canal.
Yes, that's it. And on where you've got the benches with looks like umbrellas. Can you see that?
So that's, as it were, underneath, south of what's in the canal. So when is it a platform in the canal? What, I don't understand.
Yeah, I know. There is a little outside area. There's like a platform there. So if I can just.
So is that over the water?
Yes, there is. It goes down. There's it must be like a birthing or something like that. But I can't see myself on the screen, but I'll show you. I've highlighted it. Can you see what I've done?
Yeah, that's what I'm looking at too.
Yeah. But what it is that I was just the residents in the terraces are here, madam, but that's not shown on the plan.
Over there.
Yeah, over there. So that's the terraces, and obviously this is the side gate. That's for deliveries only. Our customers will come through here and have access this way.
Okay.
I hope I've explained that clearly.
Yeah. Thank you.
Thank you.
Okay. Councillor Bell, do we have further clarifications?
No, I think we move to the discussion stage. Okay.
I think the legal advisors indicated. Sorry, madam.
Sorry, I don't know if you had a response about the CCTV footage that was requested by the police. Was there any explanation about that?
Yes, it's a simple explanation that the officer said that they wanted it to download and they will come back and collect it. So, and I don't believe the officers come back.
Would the police like to give us their response to that, please? Seeing as we're in the discussion phase now.
Yes, my understanding from the officer is that we asked them to contact us when it was convenient for us to either go and get it or it was ready for us to collect, and we haven't heard anything. That's my understanding.
Mr. Dadds, I don't know how long you've been in touch with your client. Is this reasonably recent, or, I mean, can you answer how that could have happened? Somebody should have advised your client that they need to do this.
Well, I spoke to the client late yesterday because I received the supplementary report from the officer. So I spoke to him very late yesterday afternoon. And I think it's just down to a misunderstanding between the parties. So after the hearing today, I'll be in touch with the police service about the CCTV.
I think I read it out earlier, but the condition on the license says recording should be made available immediately upon request of the police.
Yes, I don't think they requested it immediately. I think they just wanted to download it, and I think they were, as my client understands it, will come along and collect it. So I think it's just as simple as that.
Carried out immediately in any sense?
Pardon?
It's clearly not been carried out immediately in any sense.
No, it was immediate. So as I understand it, is the police officer said if you could do it. So that was the request, and they fulfilled the request of the police service. So and it's for them to come and collect.
They did make it available immediately.
Well, the police didn't ask for it immediately. They asked for it to be downloaded for them to collect. So we've dealt with their request.
Could we have just a clarification from the police about why they made that request again, just so we get that clear? What the incident concerned and the date and all that, if you don't mind.
The incident was the 11th and 12th of September, the late and early hours of the 12th of September, with the engagement party that led to police being called.
Okay, and do we have, was there a TENS in place for that event?
No.
No. Okay.
Madam, can I just answer a little bit more detail about that event, if you will allow me?
Absolutely, because I noticed you haven't referred to it until now. So yes.
Yeah, I apologise. As I understand it, there was an engagement party booked for 30 people. The families were told that people would have to be in effect bubbles of 6. They've obviously kept it to the maximum of 30, but I think that in itself is, the bubbles of 6 is allowed. The 30 is in relation, I think, to the actual ceremony of a wedding, not an engagement. But I'll comment on that. But in relation to the event, as I understand it, it was booked by an individual. But when the guest arrived, and there was food, so there was compliance at food, and it was by waiter service. The more people turned up than they had booked. They were asked, and more people turned up when they were asked to leave. And my understanding was that they refused to leave at the request. So the right and proper thing was done, where the police service was called and said that someone was on the premises and they wouldn't leave. In relation to reference, it says that police were called to a large travellers at the venue. In relation to the description, I would say it was that we called in relation to a large group of individuals that wouldn't leave. Obviously, we can't discriminate against any group or party that comes to the premises. My client, to be clear, did the booking, would have expected, and they've done bookings before and never had an issue arise where people would refuse to leave. So on that basis, they telephoned the police service. I'm not too sure why there is the description of traveller in it, because obviously I think the ethnicity or otherwise, the description is not relevant to the description.
Absolutely, but the point is just.
So I think in relation to, there was no crime disorder as I understand it.
Okay.
There was just a refusal to leave, and that was with the police service.
Okay, that's fine. The police would have liked to have doubtless the CCTV of that.
Of course.
Okay. Any further clarifications? No, sorry, we're in the discussion phase. Anybody? Sorry, I know I haven't been watching the screen, so Channing.
Chair, I'd just like to comment on some of the points that have been raised by Mr. Dads. The use of a PACE interview in a review hearing, it is quite commonplace, and you can check this with the legal officer should you wish to. We do accept that some of the data, the address, etc., should have been removed. We apologise for that. With regards to the suggestion that the licensing objectives have not been undermined, when in Appendix D, you can see the complaints from the residents the licensing service has received, which suggests the licensing objectives are at risk of being undermined. And in the test purchases, which shows that condition 31 has not been complied with, that clearly shows that the crime and disorder objective has been undermined. Also, Mr. Dad's statement that the ancillary food to food condition was agreed to at the hearing of the police, even though that was not the original intention of the premises, it's still the licensee's responsibility to comply with that condition. So during the PACE interview, it's been made clear to the actual licensee what is required if they want to remove that condition, and what they need to do to submit the correct application. And following that, there's still a failed test purchase. And following that, we still have further complaints about the incident on the 12th. So those are just some points of contention that I'd like to note for the record, Chair.
Thank you.
Chair, I think we need to refer to the second test purchase on the 17th of July. So the PACE interview was in February of 2020.
That's correct, Chair.
And yet the test purchase on 17th of July still had condition 31 being breached.
Yes.
So there's no way the applicant or the licensee did not know about the breach of conditions at that stage.
That's correct, Chair. That would be our interpretation of what is being said in the interview.
Does the whole pattern of incidents give you any confidence in this particular licensee?
Sorry, Chair, I can't hear you clearly.
The pattern of incidents give you any confidence in this particular licensee?
No, Chair, which is why we've applied for the review.
Could I possibly comment, Chair?
Yes, Mr. Gardner.
I'm not too sure if that's because I'm not used to this virtual. I don't know if that's what you want me to do. Just come in. And, Yep. So I'd like to just make two brief points. The first one is on the statutory guidance 1120 sets out in deciding which powers to evoke. It's expected the licensing authority should, so far as possible, seek to establish the cause or causes of concern. The remedial action should generally be directed at those causes, no more than an appropriate and proportionate response to address that original concern. So the licensing authority are saying it's that breach of that condition. We believe that that breach undermines the licensing objectives, but you've heard from me that actually we have agreed that condition, not fully understanding it and appreciating it from the police service. The police service have agreed to remove that condition as not being necessarily important.
No, sorry, Mr. Daz. The point the licensing officer was making was that the PACE interview made it very clear to the premises licence holder that that condition was in place.
Yes, but I'm addressing you on 2 points.
The subsequent purchases were a repeated breach of that condition, by which time she surely did understand what those conditions meant, and that it was required for her to alter those conditions in order to do what she'd previously been doing legally. And that seems that's fair enough. I think that point was made.
I wanted to make 2 points. What I'm trying to say is that the decision that is made today, you have to identify the cause or causes of concern. So I'm making representation. You don't have to agree with me.
No, I understand.
But what I'm saying is that there's two components to it. One, the breach, and two, about the confidence. And I'll deal with the confidence point in a minute. But in relation to the breach, if we look at it as a pure breach of that condition, if it's the alleged breach, if we remove that condition, that cause of concern goes away, because it, from the condition point of view, after today, because it's no longer there. The person that sought to have it was the police service, and they are happy for it to be removed.
The person may have sought to have it, but it was decided by a committee. And
no, it wasn't. It wasn't a committee. It wasn't a committee that decided it. It wasn't a committee. It was agreed beforehand.
Okay, well, whatever. The point is, we understand that your client didn't understand, but we also understand the licensing officer intervened to say that the client was subsequently made to understand the situation, and that's still the de facto situation now.
Yes.
And stands now, because we're not hearing the variation now, and we're not addressing the police conditions. They are for the future hearing. In this review hearing now, those conditions stand, and that understanding that the licensing officer's drawn our licensing enforcement officers drawn our attention to.
Yeah. And in my representation,
I don't think we need to discuss this anymore, Mr. Daz, unless you have something very, very much that you want to say. I mean, I think we understand what you've said.
No, I don't think you have, madam. I think that your summary of it just then gives me concern that you haven't understood what I'm saying. So would you just give me an opportunity to just readdress you on the point, so I've made myself clear and had the opportunity to make myself clear? I'm going to do it in reverse. I'm now going to address the point about confidence and then go back to the point I was just making, so that you understand what I'm saying in its totality. In relation to the confidence, the officer said that in relation to the PACE interview, it was made clear that alcohol must be ancillary to food, and that was accepted back in February. In the July, my client made it clear in the interview that there would be staff retraining, and that when the individual came in July, there was an expectation that the person would in effect purchase their drink, go to the table, and then order their food. And they've said, well, you can't do that. You must make sure that you're ordering the drink, and that they are going to, you have to be sure that they're going to participate in buying food. So that was the position in the July. But I go back to the
July
point
2020 or 2019?
2020. This I think it's this year, isn't it? 2020.
Yeah.
And what I say, my first point, which you stopped me on, which is absolutely fine, but I want to just repeat it. I have offered in my representation that you amend this license, which you can do on the review. One of your powers is to amend. And what I'm saying is that it's there's been no crime as a consequence or any material breach of of the licensing objectives because of this breach. There's been a breach or alleged breach, but that hasn't, as a consequence, undermined the licensing objectives. There's not even been a prosecution by the licensing authority.
Sorry, the talk of prosecution is unnecessary here.
Right, so, well, that's what I'm saying.
A review rather than a prosecution, and it's better for your client that that's the case.
Yeah, but here, what I'm saying is that the issue regarding the condition 31, if you accept my invitation to remove it, and you know also that the police are content for it to be removed, and that should address the issue. But as I said to you, and I want to get this point, the licensing authority didn't impose the condition, and I think it is relevant because it was my client who agreed that condition, not fully understanding the consequence with the police. Now we've had a discussion with the police. Police accept that actually it's a condition that can be removed.
Which is their view, but not necessarily licensing's view, and they've brought this review and they've entered into negotiations with your client regarding this condition. Regardless of whose condition it was, it's their job to make sure that the premises license holder understands the conditions and applies them, as they have done in this case. So we agreed on that then.
Yes,
their job, and Mr. Riviere has actually just simply indicated that he did his job and he made it clear, and the review came as a result of his attempts to do that. I'm making no judgments on that. I'm just saying that was the clarification that he made, and it seems to me entirely fair enough. And I accept your point about, you made your point that the condition came originally from the police, but that doesn't prevent licensing from making a point about that condition being in place.
And all I'm saying,
their job to support conditions, whoever suggested them in the first place. Okay.
And I would say very simply, in 60 seconds on this point to finish it, is that on the review is about undermining the licensing objectives.
Absolutely.
From an enforcement point.
Yeah. You've accidentally muted yourself.
So from a review point of view, it's about the promotional licensing objectives, undermining them. In relation to enforcement, you would take a graduated approach to enforcement, give a warning or caution or prosecute, and that would be the route. But obviously you can't say use the review process to, in effect, usurp the prosecution point. The reason why is because the statutory guidance says you shouldn't be establishing innocence or guilt on a review.
We're not. We have no intention of so doing. Thank you. Thank you.
Thank you.
Okay. Anybody else wish to make any discussion points before we move to final?
Well, I could pick up the point with Amanda and clarify that everything recorded in the PACE interview is entirely to be taken into account in the meeting.
Yes, Councillor Bell, you are entitled to take into consideration the PACE interview. It is quite common practice for PACE interviews to be used as part of the evidence of a review hearing, particularly if it's relevant, and there isn't an issue there.
Thank you.
Thank you.
And obviously, I've given a different view, legal view, which obviously I'm entitled to express on behalf of the client, that in fact use of the PACE interview is a breach of the GDPR rules, because the PACE interview, the person was called in, they came in voluntarily and gave the interview and the information in accordance with an investigation of a crime, not in relation to a review hearing. And there is personal data in the PACE interview and matters which are not relevant to the review that's been disclosed and should not have been disclosed.
Which that data you did receive an apology earlier on. Yes.
Yes, that's right.
Yeah, Chair, I'd just like to point out that that data has been redacted from the the actual interview transcript. And again, just pointing out the grounds for review, which is it contends Mr. Dadd's view with regards to the guidance on the Licensing Act, Section 182, Chapter 1110, where authorised persons and responsible authorities have concerns about problems identified at a premises. It's good practice for them to inform licence holders early warning of their concerns and the need for improvement. And where possible, they should advise the licence or certificate holder of the steps they need to take to address those concerns. A failure by the holder to respond to such warnings is expected to lead to the decision to apply for a review. So that's why we're in the position that we're in now, where we've applied for a review, because we have engaged with the licensee. And we have let them know through letters and through engagement and the interview what is required.
Well, they could have advised that they could have applied for a variation.
Okay.
They were advised of that in February in the interview.
That did happen. Thank you. Yes.
Again, Mr. Riviera, is it your case that graduated steps did occur in terms of your advice to the licensee?
Yes, Chair. If you look at the documents that are included, you'll see warning letters, and then you'll see the failed test purchase, and then you'll see the PACE interview, and then you'll see another failed test purchase.
Okay. Do we are we happy now to proceed to final remarks on the review? Yes. Okay. Thank you. I'll go. I think we don't need to hear from the environmental health, so we'll hear from the police for your final remarks, please.
Thank you. I just wanted to point out really that from police, we felt it was important to acknowledge that there have been issues at the venue, but having spoken to Mr. Dadds and his client, we're keen to find a way forward. The issues that we've spoken about have been addressed, but as we've already discussed, it's quite complicated with having a review and a variation being submitted at the same time. So we have kind of addressed those issues through the variation process. Whether that's right or wrong, I don't know, but that's what we've done in this case. We acknowledge they haven't been operating within the licence, but we think that concerns could be allayed through the variation process.
That's very helpful. Thank you. Okay. Channing from licensing, do you want to?
Chair, just to add to what I've said already, we do have concerns about the compliance with the licence, and unfortunately we do not have the confidence that the licensee can operate the licence in a manner that supports the licence objectives. We believe that the failure to provide the CCTV to the police would further suggest that we're right to not have confidence in the licensee. And also, if you just refer to Officer Samantha Mathis's statement and her attached photo from her test purchase, then I believe you can see the licensee was actually behind the bar at the time when she was served. So to suggest it may be a training issue or there may be other factors which are stopping them from complying with this condition 31, which they've been made well aware of, it doesn't really sit well with us. So unfortunately for the licensee, our position is still the same because we do not believe that they can comply with the license as it is.
Thank you. Mr. Dadds?
Yes, I'm going to be a little bit longer, but I'd like to start with there are in effect four parties. The residents we've not heard from, but we've got written representations, but we have heard from environmental health. There's been no further complaint since steps have been put in place. Then we have environmental health, and we have engaged with environmental health. You've heard that. It's very positive. We've engaged. taken steps, spent about £110,000 between 110 on addressing those issues, substantial investment, substantial engagement, and it's all been positive, and they are satisfied that we can promote the licensing objective and have withdrawn. The next party is the police. Well, we've engaged with the police. The police have not provided any evidence of any substantial crime disorder or any undermining of the crime objective. And in fact, the police are keen to say, as they said, to find a way forward. And they believe that they can address that by agreeing a number of conditions, which is removing condition 31. Furthermore, under the statutory guidance 2.1, it says that the licensing authority should look to the police as the main source of advice in relation to crime disorder. And the police are satisfied that licensing objectives can be promoted. Excuse me one moment. Can be promoted. Then we're left with, in effect, the applicant, the licensing authority. And the licensing authority, I think, are taking the review as a sort of de facto prosecution, because if there is a issue arising in relation to alleged crime, as you've identified, we're not here to establish an innocence or guilt. It hasn't been prosecuted. It's subject to sub judice. The PACE interview should not be disclosed because it's subject to sub judice. The guidance is clear. We can't determine innocence or guilt of those alleged breaches. You can't say that there are alleged breaches because you'll be establishing, in my view, that point which it says you shouldn't. But nevertheless, the officer says it's compliance with the condition 31 that they are concerned with that won't be complied with. Well, if you remove the condition 31, which you can do, madam, on this review, then that matter is resolved, because there's no other condition other than alcohol ancillary to food that is breached. There's no other matter arising from the licensing authority's point of view. And as I say, it's perhaps the engagement is not as well as the engagement for environmental health, or the engagement with the residents, or an engagement with the police. Something's clearly not there with the licensing authority. But maybe they take an enforcement point of view rather than how do we promote the licensing objectives going forward.
Please don't try and interpret. I think we've got, I completely understand your point, but please, we don't need your interpretation. Thank you.
Well, it's my opinion, so I'm just trying to articulate that. That's what I'm here to do, but obviously you don't have to take it into account. Do you want to stop me on that point?
No, I'm happy for you to go on, but just...
But look, okay, I've got the point, but I think what I'm saying is that it is about what I'm seeking to do on behalf of the premise license holder to say, look, if we really look at this, there's no serious GBHs, assaults against the person, there's none of those things. What we've got is breach of the condition, which was misunderstood. Okay, I understand it was understood during PACE interview. Nevertheless, still very difficult during the operation of this business that wants to operate as a bar. In relation to the July point, what I was saying, and maybe I was misunderstood, is that the person purchasing the alcohol, they believe would sit down and then order food. But obviously, clearly that didn't happen. They didn't proceed to order food, but they just stopped that transaction, did that transaction only, and clearly would be a breach. But obviously, we want to resolve the matter, and I have offered the committee take the following steps in my submission: limit the capacity to 95.
Yeah.
Limit the.
I'm going to stop you there because we're in a position where we will be moving on to the variation, and I believe those conditions are there, and they will then proceed into our consideration of both of those. So you don't need to go through those now. That's okay.
Thank you, madam. I'll then, on that case, I'll stop there, and then I'll add my other points when I sum up on the review.
Lovely. Thank you very much.
Thank you for the time.
Sum up on the variation.
Thank you.
Thank you. Okay, so we've done the review. We won't be making the decision now. I'm proposing that we have a comfort break of 5 minutes and resume at whatever the time is in 5 minutes. 15:25. Is that okay with everybody?
Thank you.
Okay, thank you very much.
Thank you.
Okay. Great stuff. Okay. Just wait for Amanda to be here. Right, I'm just waiting for Amanda, who I can't see. I think everybody else has come back. So we'll just hang on a second before we start the meeting. Great stuff. Okay. Okay, now we're all back. I think we'll we'll obviously move on to the application to vary the premises license. And I'll ask Suba if you would just quickly run through the application for us.
Thank you, Chair. Licensing Service received an application for variation of premises license under Section 34 of the Licensing Act 2003 for Unit 7, 224 Osman Road to vary the hours and add and remove conditions as stated in the agenda. Which I just circulated. Police have agreed conditions with the applicant, which has been circulated. So licensing, environmental enforcement and other persons' representation still remain. I have nothing else to add. Thank you, Chair.
Thank you. So just for clarification, the conditions agreed with the police would mean that the applicant has in effect reduced the hours they're asking for to 11 p.m. sale of alcohol in the week. Is that Monday to Thursday?
Sunday to Thursday.
Sunday to Thursday, yeah. Supply of alcohol till 11. Midnight, Friday and Saturday, is that correct?
Correct. 30 minutes to drinking up.
30 minutes drinking up. Okay. Okay. In that case, over to you, Mr. Dust, to put your case for the applicant.
Could I, through you, Chair, can I just clarify the environmental health? I wasn't too sure what the licensing officer, the officer presenting the report. Did she clarify that the environmental health was withdrawn?
No, environmental enforcement, they have proposed some conditions. So I can't see on the report saying that it has been agreed. It's environmental enforcement from JC?
Yeah.
Oh, I see. But the environmental health officer agreed earlier to withdraw. So that's the environmental health, not the enforcement.
Yes, that's environmental protection officer. So this is environmental enforcement regards with the waste, if you can see in your report for the condition.
Yeah.
Yeah.
So in the report, the conditions from 8 to 13.
I'm looking at page, is it page 106?
Sorry, I'm just looking on the website.
I think there are conditions at 107, which we're happy to agree. But I'll do that in my rep, if that's all right, in my presentation, Chair.
Yeah.
So if it pleases you, I'd like to just to present the application. Before I do that, best just to clarify for the record a change of the application as applied for. It's to maximum capacity of 95 customers, including the rear outside area. The rear outside area should not be used after 2100 hours, except for no more than 10 smokers who will not take any drinks, glass, or open containers outside after 2100 hours. That's an amendment of condition 24. Core hours, the hours as we've just outlined, 11 p.m. for the cessation of licensable activities during the week, Sunday through to Thursday, and midnight on Friday and Saturday with a 30-minute sort of drinking up terminal hour thereafter. The front of the venue will not be used by smokers or in the rear outside space, and the condition regarding alcohol being ancillary to food be removed, and condition for 25 referring to the outside area be modified, and that an agreement to have a written dispersal policy with the police service. With those modifications, we ask that the variation be granted, and the reason for that is that the police service, as you'll be aware, are the main source of advice in relation to crime disorder, and that we ask that you be satisfied that the licensing objective in relation to crime disorder is promoted, with those additional steps being amended and modified on the license. And if the police are satisfied with that, I'd ask that you place weight upon that. In relation to environmental health, we have undertaken a number of measures and steps regarding soundproofing, etc. You've heard. They've withdrawn their objection actually to the grant of this license in its totality, but obviously it's been amended now, so it's clear that they don't have any objections from an environmental health point of view. And once again, you would take them as the lead advice in relation to environmental health matters. In relation to the residents, I've already set out that I believe that some of the representations and the comments made relate to or frustrations because of the loss of amenity. Those comments that I made earlier, I don't want to repeat, but I ask you to take them into account and take them as read as being the same as what I said previously. Are you happy that I do that, Chair?
Yeah.
Save me repeating it, yeah. In relation to residents, there are no residents on this meeting. And following the principle of East Gwent, you'll attach what weight appropriate to those representations, given that the maker of the statement is not present to ask questions of clarification, or for the premise license or the applicant to ask questions through you, if permitted. Nevertheless, I underscore the comments made by Environmental Health that there have been no further complaints regarding the music or smoking since the smoking area had been moved. In relation to the premises, this is something perhaps to be noted here, but something that always is an option with you with either decision, is that I believe that the licensing objectives be promoted. If you felt that the DPS needed to be changed, we would change the DPS if necessary, but no one's asked for that. I don't think it is necessary, but during the intervening break, if that satisfies the licensing authority, we would agree to it, but I don't believe it's necessary. But we have got another manager on the premises that we can use as a designated premises supervisor if you felt that that was appropriate. I believe that the hours sought and with the conditions modified, there will be no undermining of the licensing objectives. That's shared by Environmental Health and the Police Service. In relation to the licensing authority, the statutory guidance is quite clear that they've got to be careful not to duplicate the roles and responsibility of the other responsible authorities like the police and Environmental Health, who are the experts in those areas. The licensing authority obviously have raised concerns and do have concerns regarding breaches of conditions, or condition 31. But as that is being, we're asking that to be removed, and the other responsible authorities don't object. We believe that will address their concern about that breach, and there will be no further breach. There are no other matters arising in relation to the conditions. There is no licensing authority have not brought any issues of crime and disorder in relation to patrons. And I've not seen any evidence directly of any observations made by the licensing authority regarding any breakout noise or any noise disturbance by members of our customers to members of the public. Opposite the way, which I demonstrated on the plan, there are many residential premises across the road and the canal, and they have not raised any objections. So unless I can assist you further, we ask that this variation application be made and that the licensing objectives can be promoted with these additional steps and modifications of the license. But I did notice as I was speaking that the legal advisor has raised her hand, so I'll pause for a moment in case I need to address anything.
Okay.
Yes, sorry. Thank you very much. Just a quick query is the police on their list of conditions didn't mention anything about the hours for the regulated entertainment, and could you clarify whether those hours are reduced as well?
Yes, that's why I clarified that all licensable activities will cease at 2300 hours Sunday to Thursday, and that and midnight on Friday and Saturday. So that's to do with all licensable activities, Chair. That's why I rephrased it that way. I've lost my client, so could you just bear with me a minute while I just get them back online?
Mm-hmm.
Right, sorry about it. So, if there's no other matters arising, then that is my summary submission on behalf of the applicant for the variation of the premises license, Chair.
Okay, so sorry, just clarifying the changes to the existing license, because
Yes.
the supply of alcohol for the consumption off the premises, is that to enable the customers to be served in the garden?
Yes, it is. It may be that we just we don't have off, but we accept that the plan drawn as it is in that garden area is the on. But I've put it there for that purpose just in case. So the intention is not to do off sales, but to allow for the consumption in the garden, the outside space.
And that presumably would be, as it was suggested before, has already been in open containers. Are there any, we have conditions, condition 25.
Yes, and that will have to be modified to say that except for the outside designated drinking area, which is on the plan 105.
Okay. I think that's the only lack of clarity for me at the moment.
Thank you.
Oh no.
What's support for on the
So we're getting rid of 31, both aspects of 31, both the request is to get rid of both the meal and the waitress service?
Yes, so it gets rid of the condition 31. So we are still, Chair, doing food. So and we still have obviously waitress service, but it's not a condition that we do it for everyone. But obviously at the moment, as you know, we've got restrictions for at least 6 months. So it's table service only.
So this would, so just to be clear, under the previous license, there wasn't agreement for alcohol to be sold for people to drink in the garden area at all?
No.
Okay.
There is a point which I don't really want to really have to expand on too much, but they're under the Business and Planning Act 2020 allowed for premises that had on to be able to do off.
Yeah.
But obviously there were disqualifying provisions.
Yeah.
But the disqualifying provisions related to a variation of application, not minor variation. I was one of the lawyers that were advising the Home Office and assisted in the drafting of that piece of legislation as well as the guidance. So therefore, the local authority has said that a disqualifying event was the minor variation. But my opinion is that a minor variation can't be used to add or modify a license to allow for off sales. So
and this point is because the use of the garden has only been during COVID.
Yes.
Well, I'm not sure actually from when. From
the 22nd of July.
Okay.
Or July anyway, but I think it's academic because obviously what I'm asking for in this variation addresses that in any event.
Okay, and just to be clear, the application doesn't currently have the, as it were, the red line drawn around the garden and that pontoon area as such.
Yes, there has a line.
So,
it does have a line around it, but I think it would be helpful if I perhaps got someone in the office here to draw a red line, and I could email it to your clerk whilst we're having the hearing, if you like.
So, and that would enable the application to be for on sales up till 9 o'clock to the whole area, and after 9 o'clock just to inside, and therefore not for off sales.
Actually, can I make it absolutely clear that that area outside is for consumption only? There'll be no on sales in that area. Consumption only in that garden area. So what I've done now, so that you can see, I've done that on the plan because I can't see my screen, so I don't know what you can see.
Mm-hmm.
But what I'm happy to do is accept that, and I can email that to your officers to say that that area etched in red is for consumption only. No licensable activities, but consumption only. So no music, no licensable activities other than consumption only outdoors.
Okay.
Would you like me to send you that?
That's I don't know. It probably would go to the licensing.
Because normally I would hand it up to you if you were here.
Yeah.
But I can scan it and email it to you, to your licensing administrative officer here.
Okay. Well, we'll note that that would be useful. I'm not. Okay. Any more clarifying, Brian?
Can I just clarify what's applied for on a Sunday?
The terminal hour is 2,300 hours. 30 minutes drinking up.
That's not what you applied for. It only goes 2,200 on Sunday.
I can't hear you, Councillor Bill, very well. Sorry, one moment.
The application only goes to 2,200 hours on a Sunday.
Yes, well then that's all we can apply for. So therefore, please, will you not take into account what I said in relation to Sunday? We cannot ask for more than what we applied for. But let me just check one minute on the existing licence. Will you bear with 1 minute?
There is, however, no drinking up time allowed on a Sunday.
No, what it is, Councillor Bell, what I can do is, in effect, I'm withdrawing that part of the application because the licence currently allows for 23:30 on the licence for licence for activities. So I'm actually reducing it by 30 minutes. So in essence, what I'm saying is that Sunday, we would ask you to allow for the 2300 hours until closing. Obviously, it's your discretion that as we've applied for 2200 hours, you may say, well, no, we're going to impose that because we might. But I don't think you have to do that because we currently are licensed for Sunday until 23:30. So we're actually still offering a reduction.
Well, my interpretation would be we cannot award more than is applied for. And if your clients applied to actually reduce their hours on the Sunday, then they've applied to reduce their hours on the Sunday.
But I'm entitled to withdraw that part of the application.
You don't get to withdraw that part.
No, I can withdraw something which I asked for. So I withdraw asking for 2200 hours and leave it in place. But in fact, I want to modify it rather than leaving in place the 23:30 to reduce it to 2300 hours. We're not asking for more than what we currently have. So I can withdraw something that we asked for. It's unusual, I understand that, because normally you're withdrawing something that you're asking for that you don't currently have, which you do normally accept. However, in relation to Sunday, I withdraw what we've applied for, which will leave in place what we have. But then I'd ask that to be modified to 2300 hours. But well spotted.
It's either the modified application or the current one, not both.
Yes, but I can withdraw that from the application. Like anything else, it's a positive or a negative. You can withdraw from an application a certain component.
We have advertised this application as the application you would comment upon.
Yes, that's right. But because we're withdrawing it and not getting anything more, no one can object to the hours we currently have because we already have it. So therefore, we're withdrawing it. There's no prejudice to the public.
Yeah.
If someone made a mistake in the application, then they made a mistake.
Yes, it probably is.
Okay. Okay, so I think
Chair, the legal officer has a hand up.
Amanda.
Just one very quick question. In case I've misunderstood, there's some non-standard hours on the application, the variation application. Right? And have the police agreed those?
No, we're not. We're withdrawing all non-standard hours. We're only agreeing and modifying the hours as set out with the police service. So, if we want any additional hours, we'll apply by tens.
Okay, great, fantastic. That's great.
Okay. So we're clear on the application. Okay. The responsible authorities, I don't know if we need to hear from the police because my understanding is that you're no longer opposing this variation, but perhaps we could just have your confirmation of that, please, Tracy.
Yes, we have been in discussion with Mr. Dadds. We've agreed, obviously, the new timings, the new conditions, and we feel that the applicant will be able to operate within that licence. And so our concerns have been allayed at this time.
So just to clarify, you mentioned in that email, I think, concerns about out the front and therefore the smokers at the back. So would that mean that you were opposing off sales other than, you know, that the sales in the garden is okay, but not off sales otherwise?
I mean, having spoken to the applicant before, they said that they weren't interested in doing off sales. So my understanding was that the off sales was for the garden.
Okay.
Yeah, that's, yeah.
I mean, obviously, under the COVID law, they have permission to have off sales, although there's some debate here over whether the minor variation counts as prohibiting that.
Yeah.
So this is why I raise it with you, because you have mentioned in your email about concerns about it might be something we choose to refer to.
Right.
But that's your understanding, is that it's sales are now for the garden, and
Yes.
yeah, okay, lovely.
Chair, so that I'm absolutely clear, in fairness to the police officer, there will be no sales made in the garden, but sales will be made to allow for drinks to be taken to the garden for consumption.
Yeah.
Thank you.
And that means that are you withdrawing the application for supply of alcohol? It's consumption off the premises.
Well, it's just, no, it's actually, I think if we've just got a line around the garden, that is the premises. So therefore, and I've etched that area that says no licensable activities in that area, consumption only. So therefore, that's how you resolve that, so that there's no sale. Because we don't want a bar in that area selling alcohol. We're not asking for it. We're laying all those concerns aside to address the residents' concerns that there might have been a bar there. We're not having a bar
in the garden, is that? Yeah.
Yeah.
Okay. In that case, we'll now, if we're clear on that, we'll go over to licensing, please.
Thank you, Chair. You can see my representations on the report under Appendix B3, which I believe is on page 34. It starts on, and the actual representation on page 35. So when we received this application, our concerns do obviously link back to the reason why we submitted the review, and effectively that removing contingent 31 would allow the premises to be a wet sales premises, which is just a short walking distance from residential premises. So there's a risk here of public nuisance objective being undermined. There's a significant capacity increase also, which, even with what's been suggested as being reduced, what's on the license now is a limit of 40. And I do believe, if I heard correctly, what's being suggested is 95. So that's more than double the capacity. I make reference to this, what was supplied with the application, which was some information about noise mitigation. But the licensing authority, since making this representation, we haven't received any information about dispersal or how the licensee intends to disperse, what effectively is going to be more than double capacity at the premises. And finally, on our representation, because the review application is still outstanding, we would suggest that the application should be either refused or at least deferred until the review application is determined. And any other points, I'll save them for discussion phase, Chair.
Okay, thank you. Okay. So we're open for discussion on this now. I would like to ask the applicant how they intend to manage the outside area.
Yes, in relation to the garden area, we would have member staff going out. We have a camera in the area, and that we will close it off at 9 o'clock. There'll be a small smoking area where we will supervise it periodically through the evening to make sure that customers are respectful to our neighbours. We have already signs around the premises asking people to be respectful in relation to neighbours and keeping noise down.
Okay.
And obviously, with regards to outside the front door, there will be no allowing to be outside smoking. It's to the rear.
Can I ask just how the garden area works in terms of members of the public? Is it completely isolated from members of the public? I don't.
Yes, it's gated so that you can't access it other than coming through our premises.
So there's no towpath there?
No, it's on the other side.
Okay. Okay, so it's entirely enclosed. Yeah.
Yes, yes.
Okay.
They're obviously the occupiers of the small Mews Terrace. They have access, but obviously they have their own access and they go to their dwelling. But that's it. And there's no general access to the public. The whole site is owned by the same landlord.
Right. Okay. Okay.
Would you like me to comment on the through a discussion of the points made by licensing, just very briefly? I don't have much to say.
I'm happy for you to do that now.
Yeah. In relation to the dispersal, I'm quite happy to agree that the dispersal needs to be agreed not only with the police but the licensing authority. Happy to do that. In relation to the capacity, the premises could actually withstand and hold a lot greater figure. 95 is still relatively low, but in any event, this premises is not in a cumulative impact area. It's not. So ordinarily capacity you would probably want to restrict in the ZIZ, but this is not in the ZIZ, and normally capacity would only be put on there for safety. The fire service have not made any representations. The police are quite happy with that number, and normally the fire safety order 2010 would deal with safe occupancy. So from even though the licensing authority say, well, it's increased, but they're not the relevant authority that would normally deal with fire safety or crime disorder, and that's the police and fire service, and neither of them object. So that's all I want to say in relation to those comments in this discussion.
Janine.
Chair, my representation about the capacity was made more with reference to the public nuisance and the lack of dispersal rather than a fire safety review. Also, with the representations that have been received from residents about the application, it would suggest that residents are also concerned about it. Now, Mr. Dadds has suggested that this may be vexatious, but at the same time alluding to not knowing where the residents live. So I'm curious as to how he can decide that they are vexatious submissions from the residents. And it is double the capacity. So with the incidents that have happened just in the month of September, when the police were called, that would again raise concerns for us about the management and how they deal with increased numbers of patrons on the premises.
Thank you.
Would you like me to respond?
Yes, and actually, just while you're about it, perhaps the applicant knows from the fire what the fire limits are for the premises.
I will ask. Whilst I do that, I think the legal advisor indicated the hand. I'll ask, and maybe I can come back. So I'll just pause whilst that's happening.
Okay.
Yeah.
Yes, Amanda.
Yeah, sorry, just to confirm something. I think you have mentioned it, but I'm just double checking. You said that once you put the red line around on the plan, which will demonstrate the on sales, are you still saying that you're not seeking off sales at all? Because that's now removed from your application. Just wanted to double check that.
Yes, I think as long as the line is drawn around. Sorry, do you want me to respond, Chair? Yeah. If the line is drawn around the outside area, I believe that will be on the premises, and therefore you do not require off sales. But I just want to make it clear that we are being, if granted, we are being granted that we can make sales inside the premises for people to take out into that area for consumption.
Right.
And in relation to the capacity, my instructions are that the safe capacity is 250.
Right. Okay.
And going to the point about the residents, all I can say is that the landlord and the tenant, so this premise license holder, has had discourse with a number of the residents. So we believe we know who they are. We may not, it may not be correct, but from the representations it said 15 meters away and the use of the little garden. So we can draw what we can from that. But what we understand is no one has complained, or no one is suggesting any evidence of anyone's complaining that lives above us. And so the music noise is resolved. People going out the front onto the road out dispersing. I'm not going near the terrace because we'll be closed by 9, and there's been no complaints since we changed that part. So I think we will address the issues arising from the representations, notwithstanding I do make the point that I won't say vexatious because I don't really like that term, but there may be other reasons why they're not happy that the back area was to be used, because they lose their outside space, which is not theirs.
Okay. Okay, anybody else want to say anything now or clarify? Councillor Bell.
It's just about the number of people outside to smoke later. There's no scientific way of working out how many, but number of 10 is quite large, given that they will be talking to each other, talking on phones, and noise will be carrying throughout the neighbourhood and across the canal. I would personally like it kept closer to the current 5.
Well, would you like me to respond, Chair?
Yes.
So, Councillor Bell, that there is no scientific formula. I've generally said about 25% of capacity would normally want to smoke, or are smokers. So that brings it to 25. And then obviously you look at, well, out of them, how many of those are going to be smoking at any one time? So I think it's no more than 10. It may be less. And the current smoking arrangement seems to be working without any complaints, and we're limiting them to 10. But obviously I've made my submissions. You've heard from Environment Health that residents seem to be satisfied at the moment. And I make no further comment than that. It's a matter for you based on the evidence you hear.
I don't think we'd ever go near 25% or even close to it. Disgusting habit.
Yes, I don't like smoking. That's the only thing. Well, hopefully we'll agree on some other things, but that we definitely agree on.
Okay, so we're clear about the changes to the application. We're clear about the conditions agreed with the police and put forward now with the application. And we're clear about the plan amendment and all the details of the proposed variation, I think. Are we all, I've just realised that you're going to have to just allow me to run and get my plug because my computer is about to run out of. I'm so sorry, I have to leave the meeting just to get my charger.
So bearing in mind the chair has just left the meeting, and obviously you are down by one councillor, we will temporarily halt proceedings.
I do apologise. I'm living in a building site, so next to a building site. So it's a little difficult. Okay. Right. So, are we ready to hear people's final remarks? I think we probably are. Apologies for this. Yep. Legal officer and Councillor Bell, are we happy for that? We've heard enough. Fantastic. Thank you so much. Right. Okay. So, just going over to Kerry first from the police. Do you wish to say anything in conclusion, or are you happy?
Yeah, nothing further to add from us. Thank you, Chair.
Thank you. We'll go over to licensing to hear from you in conclusion, please.
Yeah, in conclusion, I'll just add to what I've said earlier, which is we don't believe that the application should be granted at this time until the review hearing has been determined. Also, we still have concerns about the capacity. With regards to the people being able to have off-sales due to the Business and Planning Act, what I would say is that in the Business and Planning Act that Mr. Daz has made reference to, it doesn't actually specify variation or minor variation. It just says vary a license. So perhaps the legal officer could take a view on that, on what the interpretation is. But as it stands, our position is still the same. To refuse the application, if the committee are minded to grant the application, we would suggest no off sales. Perhaps the hours from Monday to Saturday be reduced to 10 o'clock for licensable activity, with 10:30 for closing time, and no increase to capacity. That's if the committee are minded to grant the application. That's what we would suggest on the basis of the ongoing complaints as recently as September. So that would be it from our chair.
Thank you. And Mr. Daz, would you like to sum up?
Yes, please. Chair, in relation to the Business and Planning Act 2020, I think that's a matter really that is resolved outside of today. If I was to be cheeky, I would just withdraw the off-sale provision completely and not mention it. But I'm leaving it there because you can refuse it. And if it's refused, that's a disqualifying event under the Business and Planning Act. But we're not here to manipulate it. Well, what we're here is to just say, look, what do we want and how do we want it? And what I'm saying is that the only reason we've applied for the off is to ensure that the garden, we can make sure customers can leave our building, as it were, and go out to the back area outside and consume. So I'll leave that just there. Because the reason why the drafting didn't have on the disqualification minor variation is because we say minor variation is not an application you can make for off sales. So that's why it doesn't have it in the drafting. And obviously I was part of the team for the drafting. Now, in relation to the point of leave this application to be determined until after the review hearing, that would be unlawful, as you know, and that's why we're hearing this application. Paragraph 1.17 of the statutory guidance, so each application must be considered on its own merits, and you'll have regards to your licensing policy, and that you will do what is appropriate for promotion of the licensing objectives in each individual case and application. So in relation to this application, it should be considered on its own merits. In relation to the parties that have the licensing authority chap has put his hand up, which obviously slightly distracted me, but obviously I understand I get the last say, so I think, should I pause for a minute or?
Yes.
Do you want me to go?
Yes. Channing, would you like to make
Chair, I just want to add that we accept that it's at the committee's discretion as to what decisions they make, but the committee does have the power to adjourn any decision until such time as they see fit before they determine the application. That's all I want to add, Chair.
Thank you.
All right. So Madam, I'll continue if I may.
Yeah.
Obviously any adjournment of your decision is in relation to the hearing under the premise licensing regulations. It has to be in the public interest, but here the hearing has started, so your determination has to be made now and has to be done within 5 working days. So there is no discretion to exercise there. But in any event, you're not going to do that. You've heard it. You're going to make a decision, I know, in relation to based on law. But we have, as I said before, 4 parties. The police are the main source of advice on crime disorder. They don't object to the granting of this variation as modified. They believe that licensing objective will be promoted and the operator can operate it within the scope of the Act. We agree with the police in relation to that. In relation to environmental health, again, they are the licensing authority should look to them as the main source of advice. And they don't, they've withdrawn. So they don't even object to the application as applied for without it being modified. But obviously we have modified it, they have withdrawn, which means that they are satisfied that the licensing objective of prevention of public nuisance is achieved. We have no fire service raising any objections on fire safety. The residents, as you've heard from Environmental Health, have not raised any objections since, and you've heard my comments about what weight you attach. But in any event, I believe these conditions will address those concerns. And then it leaves me lastly with the licensing authority that, in effect, their representation at 111 doesn't provide any primary evidence or witness statements. It solely appears to be based on that condition. If that condition is moved, and then therefore addresses their concern about compliance with that condition because it's removed. All the other conditions have been met and not complained to or about. I don't want to comment any further about the outside drinking area because you've heard my submissions on that. But look, I'm trying to be pragmatic, Madam Chairman. I've looked at this premises, I've looked at all the facts and how the applicant got themselves into a bit of a pickle in relation to the agreeing something with the police before the committee, and how that's been very challenging for them. Businesses is challenging at this moment in time, and I ask you to take all these matters into account and say, okay, going forward, can you grant this license? Will the licensing objective be met? No issues from public health, no issues from the police. There's been no primary evidence from licensing authority. The hours set are sensible, reasonable. The conditions are sensible and reasonable. It's been operating since December 2017. No particular matters of concern that give you grave concerns that wouldn't allow for this to continue and for the license to be varied. And certainly the variation, in essence, is to remove alcohol ancillary to food inside operation. That variation will not have any effect on the licensing objective because there is no evidence that someone just having a drink would undermine the licensing objectives on this premises because there's been no evidence to that effect. And I would say that the police would object if that was the case, and they haven't. So I ask that in the round you take a pragmatic view, try to support this business that has invested terribly to address the residents' concerns about noise, their own personal expense of 60,000, 40,000 from the landlord. They've got substantial rents. They're trying to keep people employed. They're trying to keep running. They are investing in the area. As I say, if you want to, she will step aside as the DPS if you felt that was necessary. But all this is being offered up with some degree of, look, how do we get this back on track? We do want to promote the licensing objectives. Believe we can. We have been, in the last 60 seconds, we have been working with Environmental Health. We've been working to get our neighbours resolved with double glazing, secondary glazing, soundproofing, and we've been working with the police. We believe that spirit should carry through, and that should carry favour with you insofar as that it is a positive, and we want to have the opportunity to go forward with this variation to be operating without any issues arising of breach of condition 31. Unless I can assist you further, that is the conclusion of my submission on behalf of the premise licence holder.
Thank you, Mr. Daz. Thank you. Okay. With that, I think the meeting is closed. We will ask participants to leave, other than those of us that will remain behind to make the decisions. And the decision will be sent within 5 working days. Amanda, before we depart.
Apologies. I know that the applicant licensing have set out their comments, but following Mr. Dad's comment about the offer to remove the DPS, what's his view about that? Does he have any view? It's only to assist you in your decision making. Sorry.
Yeah.
Chair, that may prove helpful, but it depends on what the level of the new DPS's experience is, and it's quite difficult for us to determine that.
Yes, all I would say is that any application, Chair and Councillor Bell, would have to be made to vary the licence to include a new DPS, and the police service will have an opportunity to, in effect, vet that person to make sure that they're satisfied that they are a suitable person to be the DPS. So it's an offer because there appears to be some lack of confidence between the two licensing authority and the DPS, and I thought that that might be a compromise that could assist, and that's the reason. I don't think it's necessary, but it's offered in the spirit of compromise.
Okay, and although that has been offered in this hearing about the variation, just to check with the licensing officer and you, Mr. Dadds, that it would be okay if we decided to take that in the context of the review.
Absolutely, absolutely, yes.
Okay.
And would you like me to send this over by email?
Yes, that would be helpful, just so we've got that, because that's part really of the
Evidence
application for the variation anyway, because
yes.
Amendment is part of what was applied for, and it clarifies that for us. Okay, final clarifications all dealt with. Thank you very much to everybody for those. I think we are really now ready to say goodbye to everybody who doesn't have to go.
Okay, thank you very much for your time, councillors. Councillor Bell.
Thank you.
Okay, thank you, Chair. I'll see you. Thank you.
Thank you.